A very good morning to all the esteemed panelists and dear audience. I thanks all of you to join us on Sunday morning to discuss a very contemporary topic, which not only touches upon the lives and livelihood of lawyers, but also the public in general. Today, we have set of eminent speakers to discuss legal profession during COVID-19, challenges and solution. As we all know that legal profession in particular, even at the time of recession in 2008, didn't show a sunset. But during the COVID-19 situation, we have seen an unparalleled situation where due to closure of courts, due to shutdown or at least a partial shutdown of economy and social disruptions, we have seen that lawyers, legal professionals, in-house counsels, and many other people who are associated with this field are facing lot of professional, economic, and mental health issues. In order to discuss these issues, today we have experts, and our keynote speaker is Mr. Salman Khurshid. To give a small introduction, though he don't need an introduction, if some sophistication and charisma, wit and sobriety, looks and thoughts, style and speech, vision and mission, work and art, all these can be blended into one person, the product would be Shri Salman Khurshid. He's a towering figure in the politics. His legacy as a minister, jurist, senior advocate, and a great leader and thinker is formidable. We welcome you, sir. We have another distinguished guest, Professor Dr. Dilip Ukey. He is my Vice-Chancellor. He is a leader by example. When educational institutes in our country were grappling how to conduct classes, examinations, etc., with his swift leadership, we have already published the results and we are set to commence the new semester. Under his leadership this year, we have also introduced MA in Mediation and Conflict Resolution, which is one of the first degrees in the Asia on dispute resolution. Last year, he received an award from Indian National Bar Association for being a best academician. His scholarship in constitutional law and human rights is even recognized by Justice Krishna Iyer. Sir, we also welcome you. Next, another eminent speaker today we have is Mr. Sudhanshu Ranjan. He's a veteran journalist, author, columnist. He has written many books, and one of my favorites is Justice, Bureaucracy and Democracy in India, Boundaries and Breaches. We have watched him a lot on Doordarshan, and now it is privilege for us to hear him today also, his words of wisdom. Then today we have the man of the show, Dr. Lokendra Malik, who is the organizer of this program, leading academic lawyer of the country. And before his current practice as a lawyer in the Supreme Court, he was the professor at Indian Institute of Public Administration. His publications in different areas of law and in particular constitutional law has set a golden standard for Indian academia. He's a mentor for many first generation lawyers and he always leads by example. We also welcome you, sir. And then at last but least, we have Professor Dr. Manoj Sinha, Director of Indian Law Institute. He is known in Indian academia for his humbleness and his research contribution. As a director of ILI, he has already taken the institute to the new heights. He is the only Indian associated with Michigan Refugee Law Group headed by Professor Hathaway. He was offered for his great research work the prestigious professorship at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law, Sweden. We also welcome you, sir. Today, we are going to discuss plethora of issues. Some of them include what is the impact on the lawyers due to the closure of courts, whether there are some ways to mitigate the economic hardship of lawyers, whether shifting to virtual hearings as we are doing now is a permanent solution, whether digitization, which has been pushed now by the COVID-19, is going to stay. what is going to be the implication of the COVID-19 on the legal education and educational institutes? In particular, we know that we don't have a last mile internet connectivity, and continuously we are having circulars where we are emphasizing that legal curriculum now should be delivered in online mode. But do we have adequate infrastructure? Do we have adequate resources to do so? And in particular, this COVID-19 pandemic has bring to the surface the divide between haves and haves not. How are we going to tackle this? And in order to discuss some of these issues, uh, first of all, I would like to invite Dr. Lokendra Malik to give the welcome address. Thank you. Over to you, Dr. Malik.
Thank you, Chirag. My mentor, Mr. Salman Khurshid, former Union Minister and Senior Advocate, Supreme Court of India, and a renowned and celebrated public intellectual and prolific author. My esteemed friend, Professor Dr. Dilip Ukey, Vice-Chancellor, Maharashtra National Law University. My esteemed friend, Mr. Sudhanshu Ranjan, a renowned TV journalist and a prolific author. My esteemed friend, Professor Dr. Manoj Sinha, Director, Indian Law Institute, and a renowned scholar of international law, human rights and relations. My friends, Professor Sajid, Sheikh, and Professor Chirag, Balyan, and my dear friends who are joining, hundreds of friends are joining as participants. I welcome you all to this webinar on a very important subject. As all of us know that nowadays courts are functioning on virtual mode. Our universities are also closed and most of the transactions are made online. This COVID crisis has given many stresses and many sufferings to the people. And we thought that we should have a discussion so that we can suggest some measures and some options to the people to come out of this crisis. The government has done well, but I think more steps should be taken to give relief to the people, particularly the students community. So this is why we have arranged this discussion, and we are fortunate that today Salman Sahab is the keynote speaker who has a great experience of public life as an administrator, policy maker, intellectual, and as an eminent jurist of our country. So we look forward to receiving his scholastic thoughts and suggestions about the recent crisis so that we can suggest some alternatives, some measures to our friends in different areas, bar, and obviously the teaching institutions, colleges, and universities. So this is our today's agenda. With these words, I once again welcome you all, and I look forward to hearing the keynote speech of Salman Sahab. Thank you very much, and other panelists.
Well, good morning, friends. I must say that I find myself in a slightly difficult position because I haven't really been able to find for myself solutions for all the problems that this crisis has thrown up. And therefore, for me, this is, in a sense, an exploration because I have the benefit of the wisdom of so many of you senior colleagues who are running institutions and are running law schools. And you would have obviously, in interaction with a large number of very nervous and perplexed students, you may have found at least some leads to where we go. I will just look at two important dimensions, and there's one which I dedicate to Mr. Sudhanshu Ranjan, upon his appointment to a very important position, but because of the work that he has done, and that relates to the theoretical jurisprudential challenge that we face today. That challenge has a lot to do with the functional challenges that we face. The functional challenges have to be tweaked, have to be worked upon, have to be addressed. For instance, we have learned that it's possible to do online arbitration, online court adjudication, online conferences. We have learned a great deal about that in the past few months. And although there are difficulties on certain days, connectivity problems and so on, we seem to have overcome the immediate barrier of COVID-19 that prevents you from being face to face, either institutionally or in terms of or personally. And I think that's an important push that we've given to ourselves because of the crisis. This is not something that the legal system and people in the legal system were oblivious to. We have, for years, I have known that the Delhi High Court has been working very hard on digitalization. I know that the Supreme Court of Brazil is a paperless court, and more shifting to being paperless is something that we were contemplating, perhaps attempting, although not with the urgency that the COVID-19 has pushed us to pursue. But what we are doing today, frankly, is using platforms that are generally available in the marketplace and using them to the best possible use advantage that we can put them to in our own structures. But there is no reason why software could not be developed in our country. We don't have to wait for somebody else to develop it, but software to be developed in our own country that addresses the issue of litigation, that address the issue of adjudication, that address the issue of how we deal with in courts. Now, I just read this morning Justice Chandrachud, who has taken some very major strides in the digitalization of the legal system, particularly of introducing e-filing in the Supreme Court, that there will have to be a hybrid between the traditional forms of court proceedings and digitalized court proceedings. Now, we'll have to see how that works in times to come. But certainly, we need those from inside who know how the system functions, sitting in and working with software engineers would find appropriate platforms that would be suitable to use in court proceedings or in arbitrations. I do believe that the Delhi High Court, as I said, had done a great deal of work, including almost a decade ago under the leadership of Justice Badr Durraiz Ahmad at that time, subsequently Chief Justice of Jammu and Kashmir. And to that extent, some of the judges in the High Court are using electronic files. But I think the entire ambition and aspiration of what was attempted by the High Court at that time has not yet come to fruition. And we'll see perhaps some of this going to happen in times to come. Whatever we do, you've just pointed out an important impediment, if you like, or an impairment, or an important consideration or a drag on the system. And that will be the lack of opportunity and equality between people who are financially, economically well off and those who are not. I mean, the time when you could go under the tree to a typist who had an old Remington typewriter and get an application typed, whether you were a client or you were a lawyer, and then file it in court. Those times are gone, we know. Those times are gone. And we've accommodated and adjusted a great deal also in terms of digitalization and using of modern technology. But it is still a little bit difficult to imagine that every single lawyer, a young lawyer coming to any court, would be able to have high quality hardware, I, i.e. A laptop that provides the kind of service that you need in order to have full paperless court proceedings in which you participate. Now, we'll have to think of some ways in which this, what is sometimes called the digital gap, is to be bridged. And how can that be done? There are ways in which the finance ministry and the law ministry would find ways of doing it. There can also be a innovative manner in which the way we started with e-cafes, similarly, there could be dedicated e uh, courtrooms, of course, but also of e-lawyer rooms, that lawyer lounges in which equipment is available, but it'll have to be in large number because the number of lawyers is also very large. So something of that nature will have to be done. I think that a lot of our material that we use for arguments is available online, but many of the textbooks are not available online, and latest materials are not available online. And I think something will have to be done there as well. The problems of copyright, which already are under challenge in the Supreme Court, something which is the nature of legal material should not be treated as copyrighted in certain circumstances, etc., is still to be considered by the High Court in Delhi. Apparently, in the Supreme Court of the United States of America and in certain circuit courts, appeal courts, these matters have been considered and judgments one way or the other have been given. So I think that also will have to be considered. But I will now switch to what I said I dedicate to Mr. Sudhanshu Ranjan, is a very special concern that I feel. And I believe a lot of people feel, and some of them have expressed it in a manner which perhaps is not very palatable. Palatable in the sense that we are committed to the legal system, and we are committed to the system of courts of law, the rule of law. And despite serious disappointment with some decisions that are happening or not happening, for us to raise our voice in the public space in a manner that brings the institution itself, I will not say into disrepute, but brings the institution under a cloud of doubt, a doubt of faith, that if people begin to lose faith in the institution like the judiciary, then we will be adrift. Then there is nothing that can save us. Let's not forget that the Constitution by itself has no power. The Constitution is an idea, but that idea, in order to be enforced and implemented, requires the long arms of the judiciary and the gavel of the judiciary to come down to say, this is it, and this is what we decide is the rule of law. So I believe that we shouldn't run too easily and quickly to putting question marks on the judiciary, although an honest and reasonable criticism of decisions with which we disagree should be welcomed both by the judiciary and by anybody else concerned about the judiciary. It shouldn't be that they are like untouchable, out of reach, godlike images that for us humans are only to be revered and to be bowed to, and that we cannot ask reasonable questions. Scholarship in every democracy has always questioned decisions that courts have made, but in a manner which helps the courts in subsequent generations revive their own interpretations and relook at their own interpretations. The concern for me today, if you look at the entire conspectus of decisions that are being taken in the high courts and the Supreme Court, some in which we have felt disappointed, some in which we see enormous potential for what can happen in times to come. There are two or three points that I think become very, very clear. One point that becomes clear is that this period of COVID-19 is something that none of us have ever imagined. Those who had seen the Spanish flu and so on, those generations have passed. Nobody could have seen something like this come about, and nobody really knows where we are going in it. There are some very reasonable predictions, some projections about the way ahead, etc., etc. A major difference will happen if a cure or a vaccine is found effective, perhaps by the end of this year, but that also is a long time away. But right now, obviously, there are problems for imagination. And I see no reason why we should think that the Supreme Court or the High Court or courts at any level would not have the same problem that a thinking, average, objective citizen has. And therefore, we must factor that in when we feel that the courts are taking too long to respond. This is too large a problem for the courts to respond. And you know that there have been times when courts, if not in our country, at least abroad in the United States of America, have steered clear of what they have called the political question. They say that there are certain questions we are inadequately equipped to address and must leave to the representatives of the people rather than rush in, not knowing exactly what to do. And this is a problem I'm sure the courts have felt intensely as far as the COVID-19 is concerned. But there is a larger problem, and that larger problem is what I call the ghost of ADM Jabalpur. Now, let's not say that ADM Jabalpur was just outright wrong law, although we are accustomed to saying that when a law is decided in a manner which is unsatisfactory, or which on reflection is found to be unproductive or counterproductive or counterintuitive, such a law is reversed in our system. It's reversed by the same court that has upheld it. But you need obviously a larger number of judges to reverse something that's been done by some judges in the past. Now, what has happened is that we know that the ADM Jabalpur has been reversed by the Supreme Court implicitly in some earlier matters, but explicitly now the ADM Jabalpur has been reversed by a bench of which Justice Chandrachud was a member, and he had no hesitation in reversing and overruling something that was actually a judgment that was given by some top class judges, including his own father, who went on to become Chief Justice. So ADM Jabalpur has gone. But I believe, subject to correction, I believe that ADM Jabalpur has gone almost by instinct and a backdrop of development of rights. And rights, both in the privacy matter, the rights in the LGBTQ matter, rights that have developed from Menaka Gandhi under 21 to the recent judgments that have come, where constitutional morality has been used as a basic instrument for strengthening the rights, although there can be disagreement as there were in the Sabrimala judgment. But the idea of constitutional morality has been used to strengthening the doctrine of rights, how important rights are. What the problem with the ADM Jabalpur was that rights had been relegated to a very, very low position. But when I say that, they were relegated to a low position. Why? There are two ways of looking at rights. One is balancing the right of a person against the rights of a B person. This is something that we lawyers and legal scholars are very familiar with. It's not rocket science. It is the most simple proposition as far as law is concerned. But there is another dimension. It's not the rights of A person against the right of B person, and it could be the rights of A group as against the rights of B group, individual or group against individual or group. But another way of looking at it is rights of an individual or a group of individuals against the rights of society as a whole. Now, we have in our constitution many indications that the contest is between individual and society. The directive principles of state policy seem to indicate that. The qualifications of reasonable restrictions in Article 19 seem to indicate that. Under 25, 26, they seem to indicate that the Indian system is based on tension between individual and society, rather than being an absolute system of rights, as some people assume the American Bill of Rights is, where there are no reasonable restrictions in the text of the Constitution itself. But the restrictions are there because series of judgments of the American Supreme Court have provided that there are restrictions to free speech. Although free speech is extensive, but there are restrictions to free speech, such as elements of obscenity, etc., etc. Similarly, there is complete and unqualified freedom. They don't have a provision like Article 22. They don't have a provision like preventive detention, but yet they have in a series of cases in the past, during the war, the Supreme Court of the United States had approved internment and confinement of people of the Japanese origin into camps, simply because they felt that security was more important than the individual's right to free movement. Now that's been overruled recently in the case of legislation relating to immigration under President Trump. But the fact remains that although the American Constitution is absolute, the restrictions are imposed by court's interpretation. Our Constitution has inbuilt restrictions, and those restrictions are then further examined and substantiated by court judgments, as the court has done in Anuradha Bhasin. In Anuradha Bhasin, court has said there is freedom of speech, there's freedom of expression, and that includes the right to access 4G internet. But because of security reasons, you can impose restrictions, but the restrictions must be proportionate. So the doctrine of proportionality has been developed, as in the American system. You have the doctrine of narrow tailoring and so on and so forth, so that there has to be a compelling reason, and the compelling reason is to be satisfied with the narrowest possible band of restriction. And the same kind of reasoning we see in Anuradha Bhasin. But the fact remains that there is very little specific decision analysis on whether, when society feels it has a certain right, whether the individual right is to be swept aside by society, or is there a very special way, which seems to be indicated in the doctrine of proportionality. That how do you balance society versus an individual? When does the society prevail over individual? When does an individual prevail over society? These are very fundamental questions. And my worry about the COVID period and the crisis of the COVID period is that decisions that are being taken, particularly relating to individuals, as they were in cases of the migrant labor, as they might be in cases of what people want to do, whether it's by way of religious congregations, or it's by way of personal interface and interaction, or it is by way of having access to institutions through electronic media, or it is by way of not having to pay your fees during this period if you're a student, or it is by way of somebody saying you can't cut down my salary because of this period. Now, what is happening is, as we know in the corporate sector as well in India, that a lot of people are losing their jobs. A lot of people are getting their salary reduced to almost 50%. Unlike what has happened, as we have seen in many economies in the world, particularly economies like UK and USA, where the last drawn paycheck is protected by payments that are made by the government. Or if people are sent on COVID leave and have been asked to stay home, 80% of the salary, as in UK, comes from the government treasury. 20% is an option for the employer to give or not to give. Now, lawyers have a special problem, and the Supreme Court has recognized this. The lawyers have a special problem. The Supreme Court has recognized this, and the Supreme Court has said, why should there not be a special fund as far as the bar associations and bar council is concerned, a special fund to be able to help those lawyers who are in very special difficulty during this period. But it's come after 4 months that the Supreme Court has finally taken up cudgels for this, and I hope that there will be a sensible resolution to this problem, as the Supreme Court has required and has intended. So the lawyers will have this relief. But can there be some relief in terms of taxes? Can there be some relief in terms by which money that can be used for surviving in this period is released from whatever requirements there are of the law for that money to be paid over to the government? I think these are many questions that will have to be examined. But the bottom line will remain that, are we going to say that society's rights will prevail entirely over the rights of an individual, and will we continue to bite away the rights that individuals have and chip away the rights that individuals have, and end up post-COVID period in a phase of jurisprudence where many of the great advancements that are made from Maneka Gandhi all the way to the privacy case are taken away because there is a higher concern of society. Now, I do believe that the test lies in security versus liberty. You can't have, and I'm saying this because this is not something that we can discuss in detail today, but we can discuss it on another occasion, that you can't, by merely using the word security, take away liberty. Because if you did that, then liberty has no meaning whatsoever. Look at Anuradha Bhasin's case itself. Anuradha Bhasin, the court said, make sure that you take the least amount of liberty away. So you don't have to take away 4G in the entire state of Jammu and Kashmir. You don't have to take away 4G and give 2G, perhaps you can give 3G, and put up and set up a committee to decide this matter. The committee came back after a couple of months to say, we'll keep status quo and look at it again 2 months from now. Literally 2 days later, the Lieutenant Governor of Jammu and Kashmir says, we have no problem, 4G can be given to the citizen so that they can access classes on the online classes and communicate for purposes of health and so on and so forth. Now, this is said despite his saying to begin with that people who are adverse to India's interest might use 4G for propaganda, but then they can use this 2G as well. And that's the argument that we wanted the Supreme Court to take note of, that whatever can be done as far as an adverse interest is concerned, whatever can be done by 4G can be done by 2G as well. So either don't have the internet at all, or give them 4G, because 4G is not shown by the state to be directly contributing to an enhanced level of terrorism. Terrorism has been there for a very long time, and 4G has come more recently. So what is the link between 4G and terrorism? Now, the Lieutenant Governor himself seems to suggest there is no link, that we were only reacting subjectively, perhaps. My view would be that we were reacting by saying security is involved. And the moment you use the word security, liberty goes. Now, if that is the case, then liberty is on very shaky foundations. Security is another word for health security. One is the security from the enemy from outside. One is the security from the enemy from within. The enemy from within can be a person who's an extremist. The enemy from within can be Corona-19. So the moment security is mentioned, is liberty to lose all relevance is the question. And I think this is a very important question for us lawyers during this period, because these are the fundamentals on which we survive. We survive in this country as lawyers because we believe in liberty, that we believe in rights. And if exceptions are made in the name of security, internal or external, and the exceptions are so extensive that the very meaning of liberty disappears, then we are lost, we'll adrift, and we will have, post-COVID, a very, very disadvantaged landscape in which to work. It's important that we protect ourselves and keep our life and soul together today, but it is also important that we keep our intellectual capacity for post-COVID times, because the rebuilding of society in post-COVID times will throw up a huge amount of social conflict and therefore a huge amount of litigation. And if we have enough to survive till such time as the rebuilding begins, the restructuring of society begins, we would then have served this country well. That's my message, and I hope that we can take it into more specifics because of the contribution of my very, very learned colleagues who are here today on the panel. Thank you very much.
Thank you so much, sir, for your words of wisdom. In fact, it made me think whether there's a time to think about preventive justice. And when I say about preventive justice, we are seeing across the world that there's a rise of preventive state. There's a rise of security state. And because of the preventive turn in criminal law, everybody, when we use the word security, every individual is dangerous. And the moment the argument of dangerousness comes, all of us falls under the radar of criminal law. And I completely agree with you that we need to draw a balance. We need certain limiting principles on the preventive measures used by criminal law. Now, coming to Professor Dr. Dilip Ukey, we have heard about legal profession. We have heard about rights-based society from Shri Salman Khurshid ji. Sir, would you like to reflect something about reforms which are required in legal education? We know that at our university, first batch of the students have also passed out, and there are enormous challenges in terms of their employability, about the employability of the young lawyers. What all steps can be taken at an institute level to mitigate all these challenges? Please, sir.
Thank you, Chirag. Honorable Salman ji Khurshid, an eminent lawyer, jurist, politician, former minister, and great intellectual. Dr. Lokendra Malik, Shri Sudhanshu ji Ranjan, my friend Dr. Manoj Kumar Sinha, my colleagues Mr. Chirag, Balyan, and Mr. Sajid Sheikh, and all dear participants who have joined for today's webinar across the country. At the outset, first and foremost, I thank Dr. Malik Saab for having organized and moreover secured the presence of Shri Salman ji Khurshid and his discourse, a feast to so many, including myself. So thank you so much for that, and I congratulate the same. As when we talk about the COVID-19 and the challenges before the legal profession as well as legal education. Because when you talk about legal profession, legal education is the basis or basic foundation of the legal profession. Yes, as Mr. Chirag had pointed out that being a National Law University, we have completed our curricula due to online, on the basis of online lectures. Rather, we were the first one to impose the lockdown in the month of second week of March itself, due to the security concerns, danger which was lurking upon everybody. And then started immediately the online lectures. Online lectures were completed, and we have conducted even the examination of final year UG as well as PG, and even the results have been also declared of both as. And yes, other activities, other work, administrative work or financial matters, all those things are still going on, no doubt. But the challenges which we could see, and as those challenges, if possible, to be overcome by virtue of certain steps which are required to be taken. It is true that now not only National Law University, most of the universities, colleges, they have conducted the online lectures, and now also in some cases lectures have begun, academic session has begun, and they have started the online lectures. That is the need of the hour. There is no denial of the fact. But there are two things, two aspects of it which has to be looked into. As a teacher, and every other teacher would share with me, the kind of the content, kind of the analysis which we could do in a regular traditional mode of lectures, that is not possible by way of online lectures. Online lectures have had its own limitations. The kind of one-to-one contact which a teacher has with students, with the audience, or even webinar, that is not possible in online lectures. Moreover, there is a time constant that if it is a traditional mode, you can go on and on if required. So is not the case with the online lectures. Hence, even students, whether student is attentive, whether student is able to understand, grasp, that is not possible to be ascertained, find out, because of the constraints of the technology, because of the constraints of this mode of online lectures. That is one. Secondly, the universities or colleges or private universities in metros or corporation areas, that is fine. They are conducting the online lectures, no doubt. If we talk about from the institutional point of view, the either colleges or schools in the remote areas, Mofussil areas, as Malik ji has pointed out, Salman ji also had pointed out, that in Mofussil areas in a rural India, which resides 70% India resides, or could be more than that, resides in a rural areas and remote areas, villages which do not have the internet connectivity. The connectivity apart, when we talk about access to justice, imparting the education is one of the fundamental right. Education is one of the legal right. We know it well. Unni Krishnan, which was decided by the Indian Supreme Court way back in 93, 94, immediately after the Moini Jain, free education and right to education, and now 21A, that deals with about the education up to the age of 14 years. But otherwise, education is right. That's what rather the access to justice. Without the education, without the legal education, what kind of justice we can expect that? So accessibility, first and foremost, the question comes, challenge comes about the accessibility. Even if there is an access, then the second challenge comes is the affordability. There are various such families, we also know various such families, otherwise even in absence of COVID-19, are unable to afford such things. Of course, we may not visualize while sitting either in our offices or at home, because that class is totally different. That's what I said. the national universities or the universities in metros, corporation area, private universities, it's fine. What about those colleges? There are several colleges. I have served in area, Maharashtra, Marathwada, as a pro vice chancellor and then the acting vice chancellor. Visited several such colleges. This is not the forum to share everything with all of you. There are several colleges which were not in a position to discharge their functions, carry out their functions in a routine manner, day-to-day manner, because of the constraints, because of the poverty, because of every infrastructural shortcomings. That is one. Secondly, having served in the traditional university, the state university, there is a class of colleges. One is aided, government aided, and another one is non-aided. Colleges which receive, or particularly law colleges which receive the grants from the government, they are able to provide the salary to their teachers as well as their staff. And it is equally applicable to all the other disciplines, all the other streams. What about those colleges which are unaided, wherein the management, even though they are capable, but are not willing to. Khurshid Saab did talk about the interest. There is a conflict of interest. Where is that generosity? Where is that will? Where is that fraternity, which has been ingrained in the preamble of the Indian Constitution? And that's why ultimately it is a justice, the economic justice, a social justice. That's why. From institutions' point of view, these are the challenges, these are the issues. That is one. Secondly, it is about the examination also. We did conduct the exam, we did announce the result, no doubt, but there are definitely the issues, there are definitely the technical hitches, because in a traditional mode, we can conduct the exam in 3 years or so, and then you can carry out your assessment. So is not the case with online examination. Either you will have to switch over completely an alternate mode like MCQ, whether it would be feasible, whether it would be appropriate, whether it would test not the memory, the knowledge of the concerned student or students as such, and whatever the degree ultimately the university award, whether that will be worth. These are the other things, and that's why what kind of intellectuals, what kind of the product will produce, universities will produce, that is the big question, that is the big challenge. That is one. If you look at from the staff, I mean teachers and students point of view particularly, that when a student who is there in a class can pose the question, can verify, they can ascertain, so is not the case in case of the online lectures, in case of online classes. Similarly, the kind of attention which, because of the presence of a teacher in a classroom, a kind of attention which a student or students they give, which is not there in case of online, because we are not able to see those 50 or 60 at a time, whether somebody is attentive or somebody is not attentive. It is a loss for them. It is loss to students, which they do not realize most of the time, which they do not understand most of the time. In view of this, now, as we know, because of the COVID-19, there is no denial of the fact that this is the need of hour. Nobody would doubt about, nobody would dispute about this, that online lectures, online classes, online administration, online financial transactions are need of the hours. However, and it will be there even in future as well, though not in its entirety, whatever it is there today, but because of the experiences now which we are gaining, which we are getting, maybe it is the thing of the future as well, because it has certain advantages also, it has certain its own merits also. And because of those advantages, because of those merits, as it has certain disadvantages, it has advantages as well. The students or the candidates which are unable to join classes therein, either in a college or the university, would be able to join from his or her own place, from whichever the corner of the country or whichever corner of the world. By virtue of this, the education, and particularly we are talking about legal education, would become more relevant, more important. As Mr. Chirag has pointed out in his introductory remark, that Maharashtra National Law University, Mumbai is the first university, not only in India, but in the whole Asia, to introduce MA Executive exclusively in mediation, wherein the faculty would be drawn, rather it has been drawn already from abroad, from other countries. Even students who are willing to work into, and rather they are joining not only throughout the country, but rather even from abroad, because wherever it is provided, wherever it is possible, where people want to pursue that course there, they need to spend so much huge money. Even few of the Indians went there and spend huge money. Whereas at our place, it is at so much so reduced, substantially less cost. That's why it has its own advantages, and because of the online mode, we can do that. We are able to do that. Now, the challenges which are there now, the thing is that what could be the solutions? Yes, there is no denial of the fact that, as I said, that unless and until this situation improves, we do not know when this situation is going to improve. Khurshid Saab did mention about the vaccine. We are hoping, we are expecting that at least by the year end, the vaccine shall become available. As this COVID-19 has posed similar such challenges, similar such issues rather, not only economic issues, but rather even the health issues, the mental health of even staff, even of students, even of teachers, even of employees. Apart from losing the jobs, there are certain colleges, including some law colleges, who terminated the staff, who terminated their teachers because they are unable to pay their salary. In view of this, they are suffering from that mental illness. They are suffering from that depression, fatigue. Who knows that might give rise to, for God's sake, I'm really afraid to use that word, suicides also. That's why when the Indian Constitution, which is the suprema lex, right to life, which has been guaranteed under Article 21 of the Constitution, to live with human dignity, which also includes right to health, and I believe that right to health also includes right to mental health. These issues, these challenges, these aspects are and cannot be looked at in isolation, but rather the main issue is that how to comprehend them. They're interconnected with each other: social, economic, physical, political, so on, so forth. Even in case of the migrant workers, this is not the forum to refer to that. But Act is there, 1979 Act is there, Interstate Migrant Workers Act is there, that has not been pressed into the service. And that's why, that is the reason, any issue, any challenge, it can't be looked at from its isolation, from one way point of view. That what about that right to life, which includes right to receive wages, right to receive salary, right to work. Article 41, right to work, which is there, guaranteed under, though it is a direct principles, we know that in several such instances like Asian worker case or Moini Jain or Unni Krishnan and all other cases, or right to health, which has been held as a fundamental right guaranteed under Article 39E, which has been read in part and parcel of Article 21, Paramanand Katara, Paschim Bengal Khet Mazdoor Union, Vincent Kurian. There are several such instances wherein the Indian Supreme Court did hold this. That's why. It is an economic justice, it is a social justice, it is a political justice, it is the right to life, to live with human dignity. When there is no life, if people are unable to survive, what is the biggest challenge today is the survival. It can't be the survival of the fittest. It is a challenge before the whole world, it is a challenge before the whole humanity. That's why the notion of, the concept of, usually when we refer to the preamble, we refer to the only justice, liberty and equality. We tend to ignore, overlook the notion of fraternity, which has been there, which is there, which is most important, rather, which is the soul, not only the triangle, not only the triangle of justice, liberty, and equality, but which is to be based upon, all these things are to be based upon fraternity. It is not only the state and state alone. Of course, state needs to discharge. The directive principles are to be abided by the state. The second question is about the resources, financial resources, as well as infrastructural resources. We need to generate the resources. Institutions need to generate their resources. Unless and until resources are generated, institutions are in a position to generate the resources, it will be difficult for not only sustenance, it will be difficult for even a survival. The solution is this, that we need to generate resources. We need to, the state, when I say state, including center, including state, state level, or the Panchayati Raj, down to the Gram Panchayats. Right to health, which has been ignored till now, it is the ignored health, ignored right, overlooked right, neglected right. Always we talk about right to privacy. Always we talk about right to life. Unless you are alive, what kind of life, what kind of right to life, what kind of privacy, what kind of freedom of speech and expression, movement, residence do we talk about? Or education do we talk about? Or work we talk about? All these rights are dependent upon, based upon right to health, which has become rather most paramount one. And COVID-19 has taught us, teaching us, including the state, including the instrumentalities of the state, to learn something from such pandemic. Are we in a position? Are we able to do that? Are we learning from these experiences, these observations? We are afraid, really, because just a few days before, even in Pune, renowned senior most lawyer, rather not only lawyer, a jurist, who has lost his life because of the pandemic. In Mumbai also, as it was reported that black marketing in a medical sector, health sector, it is going on.
Sir, can you
what
please...
kind of humanity? Yes, I conclude.
Sorry, sir. I'm in a
in view of yes. In view of this, we need to learn the lessons, and I think the other panelists may throw some light upon this. Thank you so much. Sorry for exceeding the time.
Thank you so much, sir, for your words. And it's always a pleasure to hear you more and more. But we have paucity of time and we have wonderful set of speakers still left. So now I come to Shri Sudhanshu ji Ranjan to share his views on the present situation. Sir, please unmute yourself. Sir, please unmute yourself. Sudhanshu ji, unmute yourself.
Sudhanshu ji, there is a mic button on your screen. Kindly press that, sir. We are not able to hear you.
So before we fix that, I think it may take some time. Can I come to Professor Manoj Sinha to share his views on the state of legal profession and legal education? And we again come back to Mr. Sudhanshu. Please, sir.
No, sir has come. I think let him speak. No problem. Sir has come. Give him. If it doesn't work, then I'll come.
Sure, sir.
Give him 2 minutes. No issue.
Okay. Now is it all?
Yes, sir.
Thank you so much. And I find a distinguished panel, and after the erudite lectures of Salman Sahab and Dilip ji, and there are more on the panel like Manoj ji, Lokendra ji, Balyan ji and Sheikh. So it gives me a sense of trepidation also. After listening to Salman Sahab and Dilip ji, who talked about rights and other things, especially in the context of COVID-19, I am notorious for criticizing the judiciary because most of the time I've been talking on law and justice, so I'm critical of other institutions also, bureaucracy and other things. This 4 months of COVID-19, which has really caused global slump, depression, businesses have been badly hit. So it's not only lawyers, but I think almost 80% people of the country, especially India, who earn every day, and if they don't earn, they cannot have food to their meals, which is called gig economy, rose kamao, rose khao. So in that kind of economy, it's not only lawyers who are suffering. I think the majority of people are suffering, and we should think about the whole lot of people, not just about one class. But as it is said that every cloud has a silver lining, so I think that COVID-19 has also given some silver linings. And what are those silver linings? I would like to compare both medical profession and legal profession. This COVID-19 has busted many myths, exploded many myths, that our health is dependent upon doctors. It's dependent upon lifestyle because the death rate has gone down. It is a fact. And it has corroborated the past surveys that we had in 6 countries long back. Countries like Israel, Canada, there were all six countries where doctors strike for a very, very long period, and it was seen that there is a fall in death rate during the period of strike. Alexander commented while he was dying that I'm dying because of treatment from too many doctors. That was the comment of Alexander. And we find it that it is quite true. He is being vindicated even during this 4 months period. We have 90% deliveries, which are normal. When there was no lockdown, 90% deliveries were cesarean. Now there are 90% deliveries which are normal. The same applies to the legal profession. We can have experiments that if courts are closed for 1 year, do people really suffer so much? Or do people suffer when the courts are open, lawyers are working, judges are working? So the suffering is more when the courts are open or when the courts are closed. We should honestly introspect. When do people suffer more? Because when the justice is so expensive and when the judicial system has been hijacked by lawyers, judges, and the few affluent litigants, we can tweak the system. And the justice system is lost in the legalese, legerdemain, and ladila style. Then is there any hope for the common man? We're talking about rights. Internationally, the courts have given judgments in favor of the elites. Salman Sahab was talking about the Supreme Court of the United States ruling that people of Japanese origin will not have this kind of liberty. It's not only that case. Right from the beginning, we have seen even the most developed democracy like America, the Supreme Court has has ruled in favor of the racial superiority of the whites, in favor of the doctrine of discovery, that people who discover an island, they are the masters of that island and they finish off, they kill the indigenous population, and the whites have got every right to rule. They can acquire property, usurp everything, and the Supreme Court of the United States upheld all these things legally. We know Dredge Court and other judgments that we have seen in India also. We may say that the Supreme Court has expanded the rights, but what we find that in times of need, it has caved in. And whenever they have expanded the rights, the petitioner or the victims have got no relief, sorry to say. Salman Sahab was referring to Menka Gandhi. I can refer to so many other cases. What kind of relief did the petitioner get? Did Menka Gandhi get any relief? Her passport was impounded. The government changed the law. What happened? Bandhua Mukti Morcha case. What happened? You expand the right. It may be very magnificent judgment. It may sound very good to read those portions of the judgment where you espouse some philosophy which are very appealing, but when you come to the ground level, hardly any relief goes to the common man who is suffering. So I'm very sorry to say, because in this kind of legal system, where everything depends on money, where common man cannot fight cases, you are talking of rights. So COVID-19 has given you an opportunity to introspect honestly whether you need this kind of legal system. And I would like to read from the famous law reforms lecture of Lord Brougham, in which he said that it was the boast of Augustus that he found Rome of brick and he left it marble. But how much, he has written, how much nobler will be the sovereign's boast when he shall have it to say that he found law dear and left it cheap, found it in the patrimony of the rich, left it the inheritor of the poor, found it the two-edged sword of craft and oppression, left it the staff of honesty and the shield of innocence. So how do you look at the law? Perhaps you think that the courts are the only institution that can protect our rights. And I remember a very famous statement by Justice Learned Hand, one of the greatest jurists who never made it to the Apex Court of the United States, that I wonder we rest too much hopes in the Constitution, law, courts. These are false hopes. Liberty lies in the hearts of people. And so long it lies in the hearts of people, you don't need law, we don't need constitution, we don't need any other institution. And if the liberty dies in your heart, then no court, no constitution, no law can save you. So we are dying from too many laws and too many lawyers and too many judges. Too many laws and no justice. That is the irony of this country. So how to go ahead? That is the problem. Not that there is no problem. There are problems. People are cantankerous. They fight. They usurp other rights. They want to trample upon others. They will appropriate others' property. We are not so generous. Sometimes we are brutish, to use the words of Hobbes. We always want to dominate. We always want to usurp. That is the nature of some people. Not all. Though there is also another side, when you have the gift of God, the godliness that is inside you, the divinity that is inside you, that inspires you to do great things and good things for the society. But then there is the darker side, which makes you brutish, which makes you selfish. When you don't care about others, you just think about yourself, and that leads to litigation. So we cannot think of an ideal society in which there will be no litigation. That is true. But if there is litigation, then how to go ahead? In a system where it takes, which is notorious for giving dates, tarikh pe tarikh, tarikh pe tarikh. I hope you won't mind a joke which I have stated in so many seminars, that an 80-year-old man was produced before the court for what? For rape teaching. That was the allegation against him, and the judge shouted, "You shameless fellow, at this 80 the age of 80 years, you are doing this shameless thing? Did you do this?" He said, "Yes, sir, I did. But now it is a summary trial because you have pleaded guilty. You have not said you are not guilty. You are guilty." He said, "What? Yes. You're a shameless person. Had I the power to hang you, I would have hanged you, because this is so shameful, so obnoxious, so despicable." He said, "Sir, but listen to me. What, you are a shameless fellow? Still you are saying, listen to me. You are not a 20-year-old boy." That I say, okay, गलती हो गई, चलो डांट टपट के छोड़ दो, आगे से मत करना. सर, यही तो मैं कह रहा हूं कि जब मैंने किया था तो मैं 20 साल का था, 60 साल तक तारीख पे तारीख लगती रही. अब जो है मैं भी अपने पोते के साथ आया, वो अपनी पोती के साथ आई है. So that illustrates and that shows how our judicial system is functioning. This 4 months, because we get adjournments. I don't know when it will be heard. Your case will be number 33, 73, and then everything will be wound up at 23. So you don't know whether it will be heard. And even if it is heard, then what kind of judgment will be? Everything is unpredictable, totally unpredictable. Why adjournments? I don't know. Lawyers seek adjournment because every week party wants to protract. That is not the job of the lawyer. Lawyer has to be honest, because you are an officer of the court, but you are not doing that. What is the principle? If you are weak on fact and strong on law, then bank the fact. If you are weak on law and weak on fact and strong on law, then bank the law. But if you are weak on both fact and law, then bank the table. So your purpose is not to arrive at justice, but you have to help the client. And at this Right to defense, even in the most sensational, heinous crimes, knowing full well that it is hardcore criminal, this right to defense, I don't know, two expressions are most abused. One in the field of law, another in the field of media. Media is TRP, so to spruce up, to raise your TRP, you can show anything, obscenity, crime, sex, anything that gives you TRP is okay because it is giving you TRP. You don't have to do anything else. You don't have to create taste, you have to cater to the taste. So you have become a catering service like media. And in the field of law, it is the right of defense. Right of defense, so far as I understand as a layman, because I'm not a law scholar like Salman, Khurshid, or great professors and lawyers present here. I'm not a scholar. But so far as I understand, right to defense only means that no innocent person should be punished. So you have a right to defense. Not that you are a hardcore criminal and become every noted, not I would not say every, but most of the noted criminal lawyers have earned fortune from notorious criminals. That is not the purpose of the legal system or our judicial system. So when you go on prolonging, so what do you get? I think it is an adjournment for all cases for the last 4 months. Adjournment for all cases. Otherwise, also you get adjournment. And why adjournment? Why do lawyers seek adjournment? And most surprisingly, why do judges grant adjournments? Because they are not prepared. Any judge will come to the court well prepared, who has gone through the file, he will never grant adjournment because it is a wastage of his time also. So you don't come prepared, the easiest thing is to grant adjournment. You must do away with this culture of granting adjournment. No exception, not even in the case of death, because India has a unique capacity to expand any relaxation, any exception will be expanded so much. Like I would give an example, as in Christianity, it is said that a camel can pass through the eye of a needle, but a rich man cannot go to the heaven. But if you leave a space like a needle hole, I think that will expand it so much that a whole train, or rather a whole ship, will pass through it. So if you say that under these circumstances, adjournment can be granted, then that will be interpreted in such a way that on every ground the adjournment will be granted. So you have to do away with this. Even if there, in the case of death, which is very rare, then you can give written submission or written argument. And I think everything is given in the petition. There was a system in the Privy Council that senior counsel stood up and said, if your lordships have read the petition, I have nothing to add. I think the same system should obtain in our Supreme Court, High Court, and lower courts, that if there is anything else that you have not given in the petition, then you can argue. The judges have gone through the petition, so all those facts and submissions are given. Now, judges can put queries if there is any doubt, and that will not take much time. That will hardly take a few minutes, not even an hour. And you can finish off, you can write judgments, you can deliver judgments in the court. Unfortunately, the desire to go into history is so pronounced that you give judgments running to 500 pages or 1000 pages, which nobody reads. Any judge who is not able to write judgment in 20 or 25 pages is incompetent. I always give a crude example of Hanuman, who was asked to bring Sanjeevani booty because Lakshman had been shot by the arrow and he was injured badly. And where the Sukhain said that if you bring Sanjeevani booty from the Himalaya, I can save him. And so Hanuman was sent. What did Hanuman do? He brought the whole mountain because he did not recognize Sanjeevani. Had he recognized, he would have brought a twig, a small twig of Sanjeevani, but instead of bringing a twig, he brought the whole mountain. So you find the whole mountain in the judgment and you're utterly confused, flummoxed. What is the ratio? What is the obiter? You don't know. And lawyers will interpret it accordingly as per their convenience. No, in this judgment, this part is obiter. This is not ratio. So which part suits you becomes the ratio, which part does not suit you becomes the obiter. That is the general tendency. And even the well-settled laws which have been given in future, they said, no, that was obiter and it is the ratio. I don't understand when judges write the law is well settled, and even after writing well settled, they write hundreds of pages. What is the need of writing hundreds of pages? And then very conveniently copying and pasting, and nobody reads. Everybody is confused. So personally, I feel that if there was an intention to do justice in these 4 months, at least in the pending cases, all the judgments could have been delivered. That has not been done. Okay, keep the court functioning. I don't say that it should be disbanded. Keep it open. But when other officers are functioning, what is the problem in opening the courts? For the last 3-4 months, courts were not working. Still, there is summer holiday. What is the justification of summer holiday? If you need a judicial system, functioning system, then why to close after almost months of closure? Technically, it may not be closed. There might have been virtual hearing in one or two cases. You can say that it was open, but honestly, can you say that all the courts were functioning and cases were being heard? No, it was not being heard, but still you have vacation. So you can put the protocol in place. So many lawyers will be allowed inside. Judges will have distance. I don't know what is the problem. Why courts are not functioning? At least I can't. Most of the high courts are closed. Most of the district courts are closed. I don't know what is happening. So if people can live for 4 months without court, without any litigation, adjudication, and still, I don't think that there is a rebellion or there is a civil war in the society. I don't think such situation has come. So we should think whether we can live with peace, with harmony, even without going to courts. Many societies have done it. In many tribal societies, we find, because in tribal societies, we call ourselves civilized. And that is the whole problem, that we are civilized but not cultured. And I personally feel that tribals are cultured, though they may not be civilized. They may not be wearing dresses like us, but they are more civilized. They are more concerned about others. We are not concerned. As we become civilized, we become more selfish. And that's why the old debate between Nehru and Alvin, Warrior Alvin, whether the tribal should be integrated into the mainstream or they should not be integrated. Nehru was in favor of integrating them and bringing to mainstream, and Alvin always opposing, no, it is a unique culture and should not be done. But that's a different thing. It is a slight digression. What I mean to say that if you care for others, then the need for litigation will definitely come down. So far as the economic hardship is concerned, I have full sympathy and empathy for lawyers.
So sorry to interrupt you, but
Pardon. But what did someone comment?
sir, sorry to interrupt you. We are running short of time. I'm enjoying your talk personally, but would request you to conclude.
Just conclude in 1 minute.
Yes, sir.
So for that, I have my empathy. They are human beings. They are entitled to decent living, and whatever the society can do, society should do, because the right to life means right to live with dignity, and every person, not only citizen, every person is entitled to it. And for that, we have to find ways and means. But this court and culture, all these things, I think that is not the solution. Thank you so much.
Thank you so much, sir. I really enjoyed the talk, and it was such an insightful talk from you that when you say that we have to introspect that we need legal system or not, I think we also need to introspect what is the aim of life, because this COVID-19 has pushed us to think about more philosophical and fundamental questions about how we live and coexist as human beings. With this small note now, I would like to request Professor Manoj Sinha to share his words.
All right. Thank you, Balyan and Sri Salman Khurshid ji, Senior Advocate, Supreme Court of India, Professor Dilip Ukey, VC, Maharashtra National Law University, Mumbai, Sri Sudhanshu Ranjan ji, Senior Journalist, Dr. Lokendra Malik, Advocate, Supreme Court of India, and scholar, Dr. Chirag, Balyan, and Sajid. The broad topics for today is legal profession during COVID-19 situation, issues and challenges. And I'm happy that I heard three speakers, eminent speakers, and interestingly, they all spoke differently. They did not touch, there was no overlapping. Otherwise, many times we heard and we presented. We heard somebody and we repeated same thing. That has been. So I have also responsibility to not touch what has been already covered under this presentation. So in brief, I'll a couple of points which I read and which we have noticed, I will try to cover in limited time. There are two broad areas. The first on the legal profession, that is more focused on the lawyers, which Sri Salman Khurshid ji spoke in detail. but I feel there are 70 to 80% lawyers and maybe more. They are like, they earn every day and their family depends upon that earning. So they go to the court, they work for the whatever way for the bail in the ground, like, even the lower level judiciary or higher level also. So there are 70 to 80% lawyers, their earning depends on the each day appearing in the court. And of course, there are large number, like a good number of lawyers. They are not affected with this kind of situation. So we have to think and ponder over about those lawyers. So their right to livelihood is getting affected during the last 4 months. And that this has been also substantiated by the request of the chairman of the Bar Council of India, which was also in the live law and bar and bench. A request was made to the Honorable Chief Justice of India to open the court, highlighting this particular condition. And there are various regions where also mentioned in that particular opening of the court. And also the efforts of the various bars, like, from district level to the High Court or Supreme Court, the bars also try to help their brotherhood, help the lawyers, those who need some kind of money. So there were a lot of requests from the Bar Association, Bar Council of the various states, district bar level, to try to help the persons who belongs to the 70%. So there's a big questions related with the right to livelihood of the large number of lawyers. That is the concern. And I feel time has come where we have to think about, where bar has to also think about how to deal with this kind of situation in future. And maybe some strong social security system should be there. Maybe some kind of insurance scheme should be there. And that can take care of these kind of situations. So this opportunity will also given a platform to think about, not to repeat same mistake in future if these things happen again. Let me put to the legal education, now legal profession. So I said about that. Now legal education, and Professor Dilip Ukey spoke in length. What I see in India, you have 4 types of universities. You have central universities, you have state universities, you have private universities, and you have deemed universities. Central universities, around 50 central universities in India. Then you have around 409 state universities, around 3 to 350 private universities, and last is the deemed university. The problem is more confined to the state universities, which has been correctly pointed out by the Professor Ukey. What he said, the state university is affiliating colleges, aided or unaided. So a large number of colleges in India, it's run by the state university, and there we see a major problem to cope up with the COVID-19 situation. If we focus our discussion, you highlighted, Chirag, in the very beginning that you have done, because you have infrastructure, because your students are quite well off. So they have all the facilities, so system works very smoothly. In case of the National Law School, you did not face anything. But had this particular practice applied in the rural areas, I'm sure that a lot of problems, lot of challenges would have occurred during introduction of the examination in the countryside school or colleges. That is the major problem. So our approach has to be inclusive. So what I say, if you are starting digital, it's not like that. So there are 1,700 law colleges in India. And 1,023 law colleges will not say. So we have to see the bottom-up approach. We have to think about the digital inclusive. You have to play very important role. The model which you have adopted in the National Law School may be adopted, and you have to push. Your Honorable Vice-Chancellor has to push an agenda, because you work how to the other Maharashtra like colleges located not only in the law colleges can benefit with this, and maybe work with the government system to play very important role. So that is the role we have to play in the National Law School system and other law schools also, I'm saying. What I see, so digital inclusive is very important. And what is the challenge? Challenge is digital divide. So digital divide which exists. When I take the digital divide to the student context, I can clearly highlight. So when we look into the digital divide and you apply that principle in the student, you find students are also in India divided in 4 broad categories. there are students are in the 4 broad categories. The first is students who have all the facilities, like they have a good computer at home, they have a laptop when they go to the college, they have internet, everything, whatever they think, that is available. No problem for them. So they are excluded from this digital. So that for first set. Second set, a student has only a mobile phone, no not computer. So they spend a lot of time in the university library or other facilities in the university to use the computer. So there are a lot of, including me, for many years I have worked in the university to use the library computer and other places. So I save everything in the computer. So I feel that large number of students are using the computer. So once they are deprived or they denied to enter in the campus due to COVID-19, that is correct. They are denied with writing and typing. So how can they mobile can help you into come and interact, but without computer you can't type or answer. So you have to realize something. So the second category problem begins. The challenges start with the second, which also comes in the middle income group. It's not only poor people. So second category is also serious. They can attend the classes, but when it comes to type everything, they have to be going outside or somewhere where just sit, a cafe or other places. The problem in the second category. Third is a student which has only mobile. Mobile means a mobile number where they can speak, they can get connected, no Android phone. So they are also a problem. And then fourth, the student, no facilities, neither computer nor mobile nor or any other thing. So they heavily depend. So what is the role of the state? What is the role of the public spirited individual? What is the role of non-governmental organization? We all have to equip these people, and this is not possible only because only the state, because the state system function, it takes a lot of time. We all have to work and see that how. So if each university or each college, if they start looking seriously about the problems, identifying the problems, and start addressing one by one, with applying new methodology, with applying or requesting non-governmental organization, I feel that situation will be improved. So these are the 4 categories of students I have mind. So second category, third category, and fourth category have serious problem. Another important point which I have, that is related with the infrastructure. Infrastructure has to be strengthened, and there the role of the institution and also in the also to the state are very important. Let me come to the another important point which I feel, like examination part. What you see, there is a great confusion among the regulatory bodies. What UGC says one day, then go another day, and there are a lot of litigations already pending. You are lucky that you have conducted the examination, because Supreme Court of India will deliver a decision tomorrow related with the UGC guidelines. What kind of education? So you have conducted, so you are free. But the future, the colleges which are planning to conduct examination in the coming month, they have to apply the decisions of the Supreme Court. There is a case pending in the Karnataka High Court. There is a case pending in the Delhi High Court. But now tomorrow or day after tomorrow, we'll have a clear-cut decision on what Supreme Court. That will become the law of the land. That has to be applied by almost all colleges. What comes like the Supreme Court of India, I'm sure that they will be taken care of. The last point which I feel, access to education. Now access to education in one form, access like classes part you have addressed. The second important part is the library. All the law schools have good library, and students can offline, they can remote access they can have. So they are having that particular thing. But why not we think seriously about the colleges where though no e-library is there? Why not we help them? So whatever the information is available, or whatever the details or services available in your library, Maharashtra National Law University or Delhi National Law School or IP Law Schools, they open it for the public. Freely they can access. And that experiment can be very successful, where I end with suggesting that in Indian Law Institute, much before in 2014 onwards, what we have done, we have digitized our entire journal of the Indian Law Institute. We have digitized annual survey of Indian law. We have digitized all publications till 2000, whatever books we have published around 90. all the publications, read the seminar, conferences, everything, whatever, and there are rare documents, parliamentary debates, all we have digitized. We spend huge money, and that we have achieved by 2014. And then all the, like, what we have decided, we made a public library in a true sense. So our, like, and I thank honorable judges, because in the library committee we have honorable judges of the Supreme Court and High Courts. They were there. They supported the idea, make it accessible to all. In fact, we have written letters to all the vice chancellors and also all the high courts to access the library free access. So that particular approach has to be applied. Still, I feel many times people question why hard copy, why soft copy. Soft copy should not be freely available. But idea is to make the education, make the information available to all of us. The moment we adopt this approach, and I believe that you all public spirited individual, we are sitting here, we are discussing. The last point, I think this is really last point, what I'm going to emphasize. We are going through the during COVID phase. So we have a pre-COVID, during COVID, and post-COVID. So whatever the methods we are going to learn in the during COVID phase, so method of teaching online and offline, I believe strongly, and I urge honorable Vice Chancellor sitting here and others, those who are listening also, let the online classes also continue after post-COVID-19 situation, where offline and online mode of education will be integral part of the university system. So if a teacher goes somewhere to attend a conference and seminar, he can arrange his class according to his convenience. So you can say, okay, I'll take a class today 7 to 9 and the students, and then he had all the access. So my suggestion to all the, so we all have to emulate that online teaching has to continue. Even this has to be in some way, it has to continue in the examination system also, not in a huge manner, but some balance has to, whatever we are learning in this particular, we have to continue in the post-COVID-19 situation. It should not be stopped. I think all the eminent members all speakers have spoken in length about the various issues. I have also identified some of the issues. I feel if we try to address whatever discussion took place today, I'm sure things will be better for the legal education, for general education, and also it will help the needy sections of the society as well. With this, I thank all of you for inviting me, and it's a great honor for me. Thank you very much.
Thank you so much, sir. Thank you so much for your ideas and thoughts about reforms in legal education and what's the way forward. What I feel after listening to all the eminent experts, that these problems were always there. And the major problem is the problem of haves and haves not. COVID-19 has exaggerated this problem. It has brought these issues to the surface, and probably more systematic reforms are required. Not just we need to pay our lawyers, we need to think about universal basic income. We need to try to make our society more equitable and just. With this small note, now I would like to introduce Mr. Sajid Sheikh, who is Assistant Professor of Law at Maharashtra National Law University, Mumbai. He's the host for today's event, and my dear friend and colleague to give the concluding remarks. Over to you, Sajid.
Thank you so much, everyone, all the dignitaries. The motto of Lawlex organization is convergence of legal minds. And I must salute the initiative of Dr. Lokendra Malik, who converged these eminent legal minds today and brought them here for important discussion on the legal profession in COVID. Mr. Chirag, I must recognize that you had a very difficult task of moderating. And of course, you said that we need to think of ways to mitigate this hardship which all the lawyers, legal professionals are facing. And this is what was discussed by all the panelists. Dr. Malik, as he said, that more is required to be done. And of course, he talked about various petitions which are there in the courts, which have to decide on whether we have to resume the physical hearing, whether we are required to constitute a fund for the lawyers more on and so forth. Especially, I would like to thank Mr. Khurshid, who said that, yes, it is a difficult time. It is very essential right now to understand and appreciate and recognize this time that it is difficult to find foolproof solution. And of course, he laid down a way forward by saying that, some robust softwares are required to be developed. Intellectual property rights needs to be relaxed. And of course, criticism will be there, has to be there, but it has to be very, very reasonable, because even government is doing something. People from all spheres are doing their bit. So some kind of recognition should be there, and of course a reasonable criticism should be there, and a threat of security versus liberty is always there. Thank you. Also, Professor Ukey, my Vice-Chancellor, who definitely also recognized that, yes, technology has its own constraints, and there are challenges to the conducting of, examinations. There are challenges to the conduct of, normal assessments. And definitely, whatever we are doing, we also need to make it sustainable for the future. And from the center to the deep grassroots level, a sustainable, software should come up. So, whatever we are doing should be sustainable. Thank you also, Mr. Ranjan, by, recognizing that, yes, COVID-19 has shown us what are the different sides of the society. And within this, the legal system has to face these challenges and has to come up strong in this very pandemic. And we also need to be cautious with this adjournment culture. Thank you also, Dr. Sinha, for emphasizing that Bar Council should take more active role in this pandemic. And of course, better schools with better infrastructure should help others to break this digital divide. And of course, as you said, the petition with respect to the clinical courses are with Karnataka High Court, and definitely they have to decide over it. We are waiting for that very outcome. Lastly, I'll say that COVID-19 is not only a health crisis, it's a human rights crisis, it's a socio-economic crisis, but it has turned out to be an existential crisis. Be it airline industry, be it local traders, be it corporates, be it education industry, be it legal profession, all have suffered the impact of COVID. And especially the talk of today, that is the legal profession, it has suffered the most, as it was not prepared to meet the challenge. With 20 lakh lawyers in India, only a few have been able to adapt to the mysteries of digital space. Advocates' lives took a complete circle after having decades of practice in a non-conventional manner. In important cases, how can we expect bundles of old files digitized by the advocates in the lockdown all by themselves? How can such files be referred without having a robust system of e-litigation? And yes, Mr. Khurshid emphasized that we require a robust technology to deal with this. Only the non-litigation lawyers, they have done something in this, and 90% of the lawyers are left to their homes. I'll talk about, because I belong to this state of Union Territory of Jammu and Kashmir. Here, the Honorable High Court, of course, released a WhatsApp number of judges and the registry for enabling e-filing of urgent memos, but still there is a long way to go. And with the permission of Dr. Malik, I'll invite again all these very speakers that, yes, definitely, again, we should meet again after a few months and reassess this very situation. And yes, it is a wake-up call for everyone.
Professor
We
Sheikh,
must.
Professor
Yes,
Sheikh, please don't forget our hundreds of participants. I will request you to say a big thank you to all of them. I think there are more than 341 participants. So please, let us thank them also.
Yes, of course, Dr. Malik. Firstly, thank you again, sir, and thank you to all the participants who have joined us today on Zoom platform. Hundreds of participants who have joined us today live on our YouTube platform. Thank you, everyone. This COVID-19, of course, will remain for a while. It is the time we should change, we should improve, we should adapt. Thank you, everyone. Thank you all the panelists once again.
Thank you.
Yeah, thank you all.
Thank you.
Bye.
Now all the panelists, they can leave this very platform. We'll be keeping this very platform
Bye.
live in a few minutes for submission of feedbacks and other
Thank
things.
you. Thank you,
Thank you
Professor
all
Sheikh.
again.
Khuda Hafiz, inshallah, see you again.
Yes, sir. Yes, sir. Of
Thank
course,
you.
of course. If God wishes. Thank you. Thank you, everyone. Dear participants, we are now releasing the feedback form. I request everyone to please fill the feedback form to be eligible to receive a certificate. I, on behalf of Dr. Malik, on behalf of Lawlex organization, I thank you all for attending this webinar. The feedback link has already been shared. I request everyone to kindly fill this very feedback form before leaving this session. Thank you. We are also sharing this feedback link on our YouTube page. Those who are watching us live from YouTube, you can find the feedback link in the comment section. I thank you all who have joined us today on YouTube. Everyone, those who have joined us on Zoom, please submit the feedback form. I thank each one of you. A big thanks to all the people who have joined us on our YouTube page. I request you to please submit the feedback form before leaving.